So this is the nature of evidence. They don't know, if there's an eyewitness testimony, they'll record the eyewitness's statement and they think their job is over. In the case of circumstantial evidence, where you have to pick circumstances, they don't know what a chain of circumstances is. Now, this is incompetence. This is not necessarily culpable, this is incompetence. So you have a police force which is both incompetent, and when one of their own is involved, or somebody of importance is involved, then you have them fabricating evidence or suppressing evidence. Either way, grave miscarriage to justice is the result. Yeah.
If you were in the picture in 1987, what would you have
I was unfortunately, still a college student at that time.
I ask this question because, God forbid, one of us young lawyers are in a similar situation. What would you have done to, number one, ensure that the cover-up, that is the destruction of evidence, would not have happened, and number two, that the trial date was not delayed to an extent that you were left with what you have right now?
You know, I was consulted in 2002 for the first time, and that's when we decided to move the Supreme Court. So that was my first engagement with the case. Young lawyer, whether you're prosecuting or whether you're defending, I think the one thing that young lawyers must learn in the first instance, for example, if somebody is arrested today and he's produced before a magistrate for a remand, what are the rights of an accused person? How many of you know that? What are the rights of the prosecuting agency? What are the rights of an accused person? Can a voice sample be taken without permission? Can he be compelled to give handwritings without permission? What is the law on the subject? What are the kind of applications you should move? I think these are the simple things that every young lawyer must know. You must keep a docket of these applications. Because based on what you do or not do, you either compromise the rights of the accused or you compromise the rights of the prosecuting agencies. Very often prosecutors also mess up their case because they just don't know the law. So what would I have done? I would have moved application after application, pretty good at that. I would have moved application after applications, asking for seizure of weapons, because knowing that the police is failing to do it, asking why there is no test identification, asking for case diaries to be signed every day by the magistrate. Because if case diaries are not signed, you can come up 15 years later and say, wo to tha hi nahi. And there's no way we can cross-check. Right? There is a way in which documents can be preserved. And that application must be placed on record. Writ petitions have to be moved. And now there's enough law which says monitoring by the courts. So even if the police was sitting on it, I would have moved a private complaint and asked for a 156(3) order where I would have got a personal audience with the court. Right? So there are many things you can do, many innovative ways in which you can, in which survivors, victims can involve themselves in the process of ensuring that the evidence collection is of a nature which will not collapse in court, and that the charge sheet is robust, and that it will withstand the test of time, withstand cross-examination, withstand judicial scrutiny. That's the best you can do. After that, it's not in your hands. So, young lawyers, I think it's easy to enter criminal cases. People think criminal law is just about facts, and what is there? 2 sections, end of story. Actually, it's very complicated, very, very complicated. And it's only when you are in it that you realize that so many things, so many basic errors are made because you don't know the law. And maybe sometime we should think of having a little booklet of the do's and don'ts at the time of remand, at the time when, cases like this, preservation of evidence. Because the Indian police force certainly doesn't know how to preserve evidence. But we must ensure that the best possible evidence is put before courts.
Right. I think we have a question over there.
There are 2 aspects which I would like to hear about. One is the wounded official Provincial.
Yes, that's very important, yeah.
So
What happened to him? Yes,
happened
that's.
and
I'm sorry. In the narrative, I forgot to tell you about him. So that was basically the sum and substance of my case, right? This character who had been injured in the crossfire. I assume this is the truck, and they are firing indiscriminately. One of their own gets injured, and he's then taken to hospital by the platoon commander Surender Singh. In Modi Nagar, and the MLC notices that his injuries have been caused through gunshot. Now, what happens then? The original MLC disappears, magically disappears, and by the time this thing comes to court in 2008, 2009, we wake up Mohan Meekan's hospital, they say, we don't have these records, we've destroyed these records because we keep them for 7 years, nobody asked us to preserve these records. However, I think even today, that is possibly the best piece of evidence I have, because we were able to lead secondary evidence there. And the explanation given by the police officer who was injured is really not an explanation which will withstand scrutiny. So one of the better pieces of evidence on which I stand is the fact that there is no he was part of this platoon, he was part of the C company, he was the 41st Battalion, he was injured, his own commander takes him to hospital, and in his MLC, there are clear indications that the injuries are caused by gunshot, it's a result of a gunshot injury. So in the build-up in the High Court, as well as in the trial court, this was probably my strongest point, because there is no explanation. As you know, there's something called 106 of the Evidence Act, where the onus shifts. So once the judge has accepted 3 of the 6 points, that these men were killed in police firing, that these incidents happened in the manner in which the witness is saying, it was the only place the case collapsed was with respect to the identification of those 16 men. The only way I can break that is through the injuries suffered by this police officer. It was not, it didn't receive any favor in the trial court, but I'm pretty confident that that is the one piece of evidence which may change the direction of this case in the High Court.
Other issue, you talked about fabrication of evidence by the police. So what is the treatment of it by the court?
What is the?
Treatment of it in the court, as in, did they try to perjury or?
No. All those people died. All those people who,
you mentioned about fabrication of evidence.
Fabrication in the sense that they ensured that the best evidence never came up. You should actually look at the 161 statements of these poor men, these 5 people who survived. They are 5 lines. मैं so and so हूँ, मैं गांव मोहल्ला हाशिमपुरा का हूँ, 21 तारीख को मेरे ऊपर किसी ने हमला किया था, मैं अभी भी अस्पताल में हूँ, बयान सुन लिया, ठीक है. Now that's what the police records. And when I asked these men, I said, did you actually give the statement? He said, nobody came to us. Nobody came to us. We never gave the statement. So again, those were the statements. So everything they said in court, they were confronted with, because obviously if you have a 5-line statement and then you give a 14-page examination in chief, you will be extensively confronted. But the judge, to be fair to him, he said, that's fine. To that extent, he says they were natural witnesses, they were honest witnesses, they gave details which they had not given before, but I accept their testimony as gospel truth. But we were still stuck by the fact that they couldn't identify anybody.
I think we have a question there.
Yeah.
I was thinking if it's possible to, let's say, flip the case and let's say put this injured officer in top, and let's say ask this person to identify Vidhi, because at least he has suffered a serious hurt, right? So let's say ask this person to identify person. The wound has been caused by the same bullet as was used with respect to 42
Not in the criminal jurisprudence that I have learned. If there's something that you know of and I am not aware of, I don't know how an accused person can be made to see.
Let's say, if it's a matter of, I'm just thinking, I was just thinking if there is a possibility to shift.
See, we did, no, when we argued about Leeladhar's injuries, we did say, as far as he's concerned, the 106 squarely applies on him. He has to tell us how he suffered those injuries. And he did not discharge his onus. That's why I'm saying, but there is no way you can cross-examine him. I mean, he's an accused, you know, so I'm not going to go and turn criminal jurisprudence because I want to win in one case. It can be very dangerous when it comes to bite us in other cases. The fact that he has not discharged his burden under 106 is a point that we will raise. As I said, that's my best evidence. The fact that one of the members of the platoon had suffered grievous gunshot injuries.
Oh.
Yeah.
Hello.
Yeah.
Am I audible now?
Yeah, yeah.
So you said that at best your reasonable expectation is that they might indict the investigation or establish a change of command. If I could invite you to speculate, what do you think would be an unprecedented move by the court in this matter?
There could have been many unprecedented. You see, don't forget that we've lost. It's now the 29th year. You know, so I can't. If the time span was shorter, if say it was we were just dealing with 3 or 4 years, as the Supreme Court did in an unprecedented move with respect to some of the Gujarat trials, a retrial could have been. But even if they give us a retrial, we have even less evidence today than we had when we, in 2007, 2008. It's not going to serve any purpose except, you know, waste someone's time. So I think we need to be realistic about it. The High Court cannot do something completely out of the box, given the fact that this kind of time lapse has taken place. By the time it came, you see, 2006, 20 years after the incident, the charges were framed. So you've lost your best evidence anyway.
Yeah, a question here.
This is like a clear-cut case where the state authorities want to hide out evidence. Right? So what do you think the main cause is? Is it like delay or like the evidence? Evidence not having the right evidence or the delay?
Of not securing the best evidence, and it's the delay.
Had there been any judicial action immediately? There would not have been any, prevention.
Well, we do see, we never talk of dereliction of duty when it comes to the judiciary, but in almost all cases of massacres and mass crimes, there has been dereliction of duty when it comes to the judiciary. I think, see, it's great to play to the gallery and say we are monitoring 2G, 3G, 5G, 6G, and we are doing all of this, and we have the Prime Minister on our knees and all of it, which is wonderful. I'm not saying that shouldn't be done. But what happens to the real life and death stories here? You see, there's something wrong with our jurisprudence where we give corruption more importance than human life. And while corruption is a malaise and we should definitely not be supporting people who are corrupt, but for example, in Delhi, we have 26 courts, which are special courts, dedicated to the Prevention of Corruption Act trials, 26 of them, right? Each of those judges are sitting and twiddling their thumbs because they have 3 cases or 4 cases a day. On the contrary, go to a sessions court, which is not a special court, which is dealing with 302, which is dealing with 376. You have as many as 40 matters listed every day, of which 20 of them are listed for evidence. How do you explain this mismatch? Have we reached a stage where human life is of no consequence, but the fact that somebody took money is more important? Of course that is important, but not to the extent that we don't prioritize. So we have one court from 2011 to 2016, he's driven himself mad and he's driven all of us mad, doing only 2G case because he can't think anything beyond spectrum. You have another court dedicated to coal. You have a third court dedicated to another scam, or what is it, the Commonwealth scam. And you know, the cases relating to human life, which really should be. I mean, you know the case of that young journalist who was killed, Soumya Vishwanathan, is pending in a court in Saket. This is now the 8th year without a public prosecutor. For the last 4 years, there's been no special public prosecutor. What kind of madness is this, where you don't monitor these cases, but you make a big song and dance about the corruption cases that you're doing? It doesn't matter if a municipal commissioner has taken 100 rupees bribe. I can live with it. But I cannot live with a case where 44 people are killed and there is no accountability. So there is complete dereliction on the part of the judiciary. Nobody talks about it. Nobody discusses it. But I think it's about time. You people are young, do it. I mean, we've all got old and jaded, but please, this is something which needs urgent attention. That is the last bastion of freedom. And if the judiciary does not do its job, the judiciary cannot be seen taking sides, the judiciary cannot be complicit, the judiciary has to give human life situations more importance, and that's the tragedy. At the end of the day, 28 years under the watch of the judiciary. So the judiciary has to be accountable. It's all very well. We will blame the police. They're always blamed. Of course they are to be blamed. But what did you do? And early on, there could have been ways of preserving this evidence. And so you allowed it to go. So I think it's very sad, you know. And there is always the issue of class in this, you know, the class bias. So because these men belong to a very low strata of society, I'll do a parallel. It is a horrific parallel to raise in a case like this. But look at the way we react to victims, to rape survivors. If the accused come from some Ramdas colony and they've committed a terrible, terrible rape, we will lynch and we will say, hang them. But if the accused belongs to an upper strata of society, head of NGOs, head of newspapers and magazines, our response is very different. So even the way in which we respond to people is different. Poor people, whether they're victims of crime or whether they're accused of crimes, always get the rough end of the stick. I can promise you that if 44 people, God forbid, had died in Gulf links, the situation would have been very different. I don't want any of them to die in Gulf links, but I'm just giving it to you. This, unfortunately, was Mohalla Hashimpura. So there is a class, caste, religious, all kinds of biases. They didn't stand a chance in hell.